Hello and welcome to this webinar where I'm going to talk about the practice of arbitration in family cases. The topics I'm going to cover are now shown on your screen. This is a talk that is about the practice of arbitration. It is suited for people who are arbitrators, but also to practitioners who are thinking of bringing a case before an arbitration. So we will have an introduction to arbitration, look at what arbitration is, think about the role of the arbitrator, consider the importance of the form ARB1, either ARB1FS for financial cases or ARB1CS for children cases. We'll look at what I call a pre-commitment meeting or commitment meeting. We'll then think about directions. We'll then look at the final arbitration hearing, and finally consider the writing of a determination. Judges have considerable training, not just about issues of substantive law, but also about the craft of judging. In my opinion, arbitrators have to demonstrate at least a similar craft and knowledge of how to conduct arbitrations. It isn't enough just to know the substantive law. That is why I'm doing this course. So what is arbitration? Well, the nearest you get to a definition is within Section 1 of the Arbitration Act 1996, and I have cut and pasted from that section. And you'll see I've highlighted 6 points within it. First of all, arbitration must be fair, and achieving fairness within the complex matrix of a family arbitration requires specific skills. Secondly, the purpose of the arbitration is to achieve resolution. The people want to have a final determination of a family issue that they have not been able to resolve themselves and which is not susceptible to mediation or other forms of NCDR. The tribunal must be impartial, and we're going to look at that in more detail in a moment. Fourthly, one of the big advantages of arbitration is that it is conducted without the same degree of delay that is often experienced within the court process. And because of that, it can limit the expense to the parties. However, there has to be regard to the need for appropriate safeguards to be considered, and consideration needs to be given as to whether any safeguarding issues mean that the case is not suited for arbitration. In many cases, I would suggest arbitration makes obvious sense. It is faster. The parties, with legal help, if they have it, can select their arbitrator. It does save expense. The result is a decision that is as binding as a court decision. There is a myth, I think, about how some people will be reluctant to engage in arbitration because a party may seek to benefit from delay. I hear that argument advanced occasionally. I think it is a myth. And indeed, if you play the game of tactics of delay and the case goes wrong, then a client may very well have cause for complaint. So I think one has to treat the arguments against arbitration because of any perceived benefits of delay with considerable caution. Further, playing the game of delay in a case involving children is essentially not child-focused. So, bringing the strands together about mediation, that is on the screen now what it is. It is not mediation. It is not a private FDR. It is not an early neutral evaluation. It is entirely different from each of those. And the responsibilities of the arbitrator are entirely different to those of a mediator or evaluator. The nearest equivalent, in my opinion, is that of a judge acting in a privately paid environment. If you become involved in arbitration or are contemplating it and need an answer to a point of practice, you will find the answer in one of three places. First, within the Act itself. It is perhaps surprising that points of practice can be resolved by studying the Act itself, and we'll look at some of its provisions in a moment. But also, there is a clearly crafted set of rules for children and also for finances, and the references to those rules are now on your screen. Do look at those rules if you are becoming involved in an arbitration. They do provide the answers that you will need to procedural issues. They are not complex. They are not lengthy. It's nothing like the family procedure rules of 2010. And you will be able to read the rules for each scheme within about an hour. Now can we look at the question of selecting an arbitrator? Of course, you can leave it to the IFLA, the Institute of Family Law Arbitrators, but it would be very rare indeed, I would suggest, that you will want to do that. Part of the benefit of arbitration is that you know who the arbitrator is. You select the arbitrator and you will select someone who has specific skills in the area that you need to see covered by the arbitration. The selection of the arbitrator has to be conducted with care. The arbitration is binding upon the parties, so it is well worth taking time to make sure that you get the right arbitrator. One of the fears about arbitration that I've also heard expressed is, if we go down this route, will the client blame the solicitor if the arbitration decision is adverse? So is the client going to say, you told me to go to arbitration, you told me that this is the best arbitrator, and now we've come out with an adverse decision? I think that as long as people are treated fairly and properly and are properly informed, that they will enter the arbitration process knowing that the arbitrator will make an impartial and independent decision. I think that clients are as likely to blame a solicitor for choosing an arbitrator as they are to blame a solicitor if a case goes to court and the decision is adverse. So I don't accept that there is a point against arbitration because of a fear that the client may blame the legal advisors for having encouraged arbitration any more than there is the possibility of blame for going to court. In selecting an arbitrator, it is important to involve the clients. They need to know what's going on. It's their case. It is their money that will pay the arbitrator. So they do need information, and clients do their own research, especially on the internet. There are ways in which an arbitrator may be selected if there isn't immediate agreement. You could, one party can select 3 potential arbitrators, leaving the other party to decide which of those 3 should be chosen. Another way of dealing with it is to meet potential arbitrators with the clients and discuss the case in a pre-commitment meeting. As to the arbitrator, I think, has to consider, why should people instruct you rather than going to court or choosing someone else? If you're going to do the job, you must give parties and the lawyers involved confidence that you can deal with the case properly and fairly in accordance with the definition of arbitration that I gave at the start of this talk. Effective arbitration, I would suggest, goes way beyond simply being a good or experienced lawyer, or indeed, dare I say, attending a course on arbitration and arbitration procedure. It requires a similar craft to that of a judge. And for that reason, I thought it would be helpful to remind you of the Bangalore principles of judicial conduct. If you want to look at these more, then you can find them on the internet. But there are 6 principles of judicial conduct that I think are just as relevant to a person who wishes to act as an arbitrator. They are the principles of independence, impartiality, integrity, propriety, equality, and finally, competence and diligence. I want to look at those now, each in turn, and you can see that on the next slide. As to independence, a judge has to take an oath, which includes that he will decide cases without fear or favour. And that same requirement of being fearless and without favour applies to an arbitrator. Some of the work that an arbitrator does is exceptionally demanding. And you have to be able to reach a decision without demonstrating favoritism or indeed feeling afraid of addressing the issues that are before you. A particular problem, I think, about judging or deciding cases is the form of bias that is known as confirmation bias. Confirmation bias arises when a person receives a little information about a subject, forms a view about it, and then only receives information in a way that confirms the under-researched and ill-informed initial impression. Think of any case you have had where you've gone into court, the judge has read your opponent's skeleton argument, hasn't seen yours, and starts expressing an opinion based on that without having seen the rest of the documentation or indeed what you want to say or what the evidence is. Confirmation bias is a particularly dangerous form of unfairness that can arise when people are making decisions about others. Please don't fall into the trap. Another point under independence is this is the arbitrator. You are in charge of the arbitration, and you have to maintain that control of it. The next point, impartiality. You may have people in front of you who come from the same chambers, or you may have solicitors who instruct the arbitrator as counsel, or counsel may appear before an arbitrator who is a solicitor, where that solicitor instructs that counsel. As the arbitrator, you have to decide where the boundaries lie of what is appropriate and what is not. There may be cases where you have to consider refusing to act as the arbitrator, or where you have to recuse yourself. That is something that needs to be resolved at a very early stage. The level playing field requirement that exists within court proceedings is equally applicable to the arbitration process. You may want to think in terms of the overriding objective within the Family Procedure Rules 2010 at Part 1 as a guiding principle. The next is integrity, your own personal conduct. It involves the avoidance of impropriety or over-familiarity. It's the quality of being honest and having a consistent and uncompromising adherence to strong moral and ethical principles and values. And you have to demonstrate that as an arbitrator. Imagine if you don't, and what the clients are going to think about you in your performance. And as practitioners, that is what you're going to expect from your arbitrator. An example is keeping to time. It is really important that the arbitrator appears professional, neat, on top of the case, and doesn't let the case drift. So the next is propriety. That means conformity to conventionally accepted standards of behavior or morals. An example of where an arbitrator may have to think very carefully is about his use of AI. Be really careful about researching things on AI without cross-checking the result. There may be what are called hallucinations that will emanate from AI and will lead to misinformation about, for instance, the law. And people have got into real difficulties already over that. Be really careful as an arbitrator about what you put out on social media, because the things you put out on social media may well be picked up by the people who are going to appear in front of you and who will want to have confidence in you as somebody who is impartial. I think you have to be particularly careful about expressing political views in an open forum, just as a judge has to be careful about that. The next is equality. You may have people who experience a disability. You may have people involved in the arbitration process who experience a form of neurodiversity. You will all have had training in equality, diversity, inclusivity, and inclusion. It's really important that that training is introduced and demonstrated throughout the arbitration process. It really matters. You may have a party to litigation who has an autistic spectrum condition or ADHD, and it's very important that you adjust your procedures to reflect your understanding of the needs of that party. Finally, competence and diligence. An example is reading papers. or knowing the law and the procedure before the hearing, it will not be all right on the night. People are paying you their money for a high class performance by you, and they are paying for your experience, knowledge, and ability. So you cannot leave it till the last moment. Preparation is essential. You also have to demonstrate procedural fairness and competence and knowledge of the rules, and you will, as an arbitrator, be challenged in relation to that. You will also have to give a reasoned decision or determination and show that you have applied the law, including procedural rules. That is all part of competence and diligence within the ambit of arbitration. If you get stuck on a point of practice, then can I also suggest that you consider looking at the equal treatment bench book that is available on the internet. You put an internet search against equal treatment bench book and you'll find it. Within it, there is a very large amount of extremely well researched material about all matters of equality, diversity, inclusivity, and inclusion. Can I recommend it to you? Can I also remind you of the Advocate's Toolkit, which may provide invaluable information on an area of practice? But let me also remind you of what I call the Book of Common Sense and Courtesy, one of the best bits of advice that I had in my early days as a judge, when I think I began to develop a tendency for that awful condition known as judgeitis. It was from a friend of mine who took me to one side and said, "Stephen, just be nice to people. Just be nice to people. And if you are nice, polite, courteous to people, you will get so much more from them, and also you will leave the process feeling that you have been fair." Something that I think we don't really consider carefully enough is that of security. Right at the start of an arbitration process, there needs to be a consideration about whether there are any security issues. Are there security issues for the parties, the representatives, for you? And indeed, are there security implications for the solicitors or chambers staff? Recollect that in a court, there are security provisions that are in place, and if a party becomes angry, dysregulated, then there are measures that can be put in place urgently. In a set of chambers or in a solicitor's office, those facilities are not going to be available. So it needs to be addressed at the start, and if you are going to continue, you need to ensure that there are measures in place that will meet any needs of security. An example might be that you would want to conduct the arbitration remotely. Part of security, however, depends upon the atmosphere that the parties and the arbitrator create. And keeping people calm when they are having to resolve probably the most difficult issues that they're ever going to have to resolve in their lives is an essential part of keeping people secure. Don't allow people to get wound up by the emotion of the day. And if you feel that the case is beginning to develop that way, take a break. You will have to develop skills as an arbitrator to deal with a challenging litigant or representative. It happens just as much in arbitration as it does in court. And I invite you to reflect upon that rather simple analysis of human interaction known as transactional analysis, in which it said there are three types of interaction: adult, parent, and child. So let's imagine you are conducting an arbitration and one party, let's say it's the father, becomes extremely heated and starts shouting at you, the arbitrator, telling you you don't know what you're doing, and that the mother of the children is worthy of extreme and poorly expressed criticism. How would you deal with that? If you yell back at him, you are in what's called reactive child mode. It doesn't work. It just winds everybody up, and it isn't you serving as an arbitrator. It's you've got your emotions wrapped up in what has occurred. The parental mode would be to tell the father to sit down, shut up, don't interrupt, or you'll tell him to leave the arbitration. The parental role mode is one that is directive, but it is also emotionally engaged in what is happening. You are allowing your emotions to get involved. Adult mode is the dispassionate mode where you deal with the issue. You address what is happening, you maintain control, and you remain professional. Can I ask you to strive to maintain that adult mode? There's another form of analysis called the drama triangle, where there are 3 points to the triangle. One is the rescuer, the other is the victim, and the other is the persecutor. Very often in family cases, we cannot help but feel sympathetic to somebody, or indeed both parties. But your role as the arbitrator is not as the rescuer of the perceived underdog. You're not the champion of the underdog. You are not there to demonstrate what I call sympathy bias. You are not, therefore, the rescuer of either of the parties. And for you to be the rescuer means that you have to create a role of somebody being the victim and somebody being the persecutor. And that is a really unhealthy dynamic to allow to develop when you are trying to reach an impartial and informed decision. Can I mention pro bono arbitration? A scheme has been set up. I'm part of the scheme, and there are other senior solicitors and barristers who are prepared to offer their services pro bono in relation to serving as an arbitrator where parties are of limited means. It offers pro bono arbitration only in children cases at the moment. There are solicitors who have very kindly agreed to offer pro bono advice about arbitration, not about the substantive issues of law that arise. So they would, in a children case, they would explain that the arbitration is binding and what the procedure would be, but they would not give advice about the likely outcome. The system is only available where there is safeguarding information. There's a reason for that. Otherwise, you go into an arbitration without knowing anything of the background of the parties, save that which they tell you themselves. And any children practitioner will know the importance of having safeguarding information. So we've decided that we would only take cases after the FHDRA and the safeguarding letter had become available, or in a child focus court when the initial report had been produced. If you have any interest in getting a case within this scheme, please feel free to contact me, and I will help you with that and put you in touch with the necessary people in the event that I can't help you myself. And I want to mention the ARB1. That is the document by which parties commit themselves to the arbitration process. It is an essential document. Without it, the arbitration cannot get underway. And as an arbitrator, you cannot allow an arbitration to proceed without it. You need to ensure that the ARB1, either ARB1FS or ARB1CS, adequately defines the issues that you, the arbitrator, have to decide. And if it doesn't, don't proceed further until there is a written and agreed account of the specific issues that you, as the arbitrator, are being asked to decide. Also, as the arbitrator, you must ensure that the ARB1 is signed and dated. It seems obvious, but you'll be surprised how often that can go wrong. As with every other type of work, you have to get it right from the start. If you don't, it will go wrong later on. I want to talk now about pre-commitment meetings. These are meetings before the arbitrator finally commits to serving as the arbitrator in a given case, and also before the parties themselves commit to the arbitration process. The first question is it necessary to hold such a meeting? Very often it isn't, because the parties will know what they want resolved. They will have done their research about the arbitrator. They will have legal advice, and so it won't be necessary to have a pre-commitment meeting. But in more complex cases, or as an arbitrator where you have litigants in person, a pre-commitment meeting can be invaluable. I held one recently where I had litigants in person, and I'm extremely glad that I did so. It is that pre-commitment meeting that you can investigate what you and the parties are letting themselves in for if the arbitration proceeds. The arbitrator will need to consider, is this case within his or her area of expertise? Are the parties going to respond appropriately to you as the arbitrator? Are there reasons for recusal or refusal? At the pre-commitment meeting, you can also show that you will be in charge as the arbitrator. When I do these meetings, I hold them remotely. I set aside an hour. I expect the parties and the solicitors to be present. If, following a pre-commitment meeting, you accept the role as an arbitrator, you can then issue an order, as I've done again recently in another case, giving directions, and you can discuss those at the pre-commitment meeting if appropriate. If, however, at the pre-commitment meeting, you as the arbitrator do not wish to accept the appointment, do not feel pressurized to do so. There is a lot of excitement about becoming an arbitrator in a case. For some, people may not have served as an arbitrator before and be keen to put their training into practice. But don't allow that to leave you as the arbitrator in a position where you are swimming out of your depth. it will be a miserable experience for you, and you will not fulfill the role in the way that is expected of you. The next step will often be, after a pre-commitment meeting, a directions hearing. Getting the procedure right in advance of the final hearing is as important as it is in court proceedings. Don't cut corners, is my advice. So, at the pre-commitment meeting, what are you going to do? First of all, it needs to be recorded. And you can record things over Teams using the Teams recording facility, of course. But I would strongly recommend that nobody does any arbitration hearings without there being proper and full recording of the hearing or meeting. You will, as the arbitrator, want to engage in introductions, explain who people are, consider whether the meeting is being held without prejudice. That is important because people may start telling you all sorts of information in a financial case that is without prejudice. It's important to emphasize the confidentiality of the arbitration process and how neither party should put confidential information onto social media. For myself, I like to avoid first names. I've tried in a recent arbitration. What happens if you use first names for everybody? And I think, on balance, it is too informal. I think you should wear formal clothes and use an appropriate background. I know that I had one experience of, indeed, a judge during COVID having a skull and crossbones flag in the background when conducting remote hearings, and it's totally wrong. So be careful about your background. If you were dealing with litigants in person, treat them properly. The litigant in person in front of you could be a member of your family, a friend, appearing in front of somebody else on another day. And that is how I like to think of litigants in person. These are people going through extremely difficult times. It may be that they feel they can't afford to pay for legal representation, and your job is to help them achieve a fair resolution to the issues that they face. Also, at the pre-commitment meeting, you may want to discuss fees. I don't feel embarrassed about doing so, and you need to discuss what you're going to get paid for this and how they're going to pay you. It's much better to sort that out right at the start than get into difficulties later. And it's also important to stress that there must be no emails to the arbitrator by either party unless the email is copied into the other party, save with the express leave of the arbitrator. That is something that litigants in person in particular may not understand, and it is an essential rule. Further, at the pre-commitment meeting, you would want to consider, is this case within the relevant arbitration schemes? You need to look at the rules if you don't know what cases are within the scheme and which are not. But the time to sort that out is right at the start. You also want to consider whether there are any domestic abuse issues that preclude arbitration. Again, remember that there is no security during arbitration hearings, and there may be risk to a person who is a victim of domestic abuse. And you also need to recollect that it is not just what happens in the arbitration hearing itself. Is the whole procedure safe for those involved? You need to recollect your domestic abuse training and apply it. You'll want to discuss with them that they understand what has been said in the ARB 1 and I usually will give them the definition of arbitration so that they understand what it is. You'll want to discuss with them the timetable and whether it can be achieved. Part of that is whether you will have time to do the arbitration properly within the timetable that the parties are seeking to achieve. Quite often, at an initial stage, I'm asked, well, could you do this on paper? My advice is that you should be extremely careful before agreeing to that. There may be some very discrete issues that can be resolved without hearing from the parties orally. But on a case that I've done recently where everyone initially was saying, well, this can be done on paper, it was perfectly obvious that it could not be done fairly on paper. I then heard it for a day, and having done so, it drew firmly to my attention that it was never appropriate for the case to be considered on paper alone. If you do it on paper, you have to ensure that all relevant information is there. And as the arbitrator, you won't be able to cut across issues that may have no relevance in the same way that you can in an oral hearing. In an oral hearing, you may be able to say, yes, but that point is going nowhere, is it? Because of this, I really think we need to move on. Whereas if you do it on paper, you may have reams and reams of documents that you then have to plough through to try and identify what is essential to the process. So be careful. The next stage is the directions hearing. Again, it's as important as the directions hearing within the court process. If directions are not given in a way that allows the proper determination of the arbitration, then you will get to the final hearings. The parties will spend a lot of money, you will spend a lot of time, and the arbitration will have to be adjourned. Please don't let that happen. So the directions hearing is important. I prepare fully for a directions hearing. I get a bundle, I read it, I prepare notes, and also I will often send out a note in advance of the directions hearing saying, this is the agenda that I think we should follow, and these are the issues that I think we should address. Sometimes you will get a lot of help with directions, where there are solicitors or direct access counsel involved. You will be helped. Sometimes, if you're dealing with litigants in person, you won't get help because they won't know what the expectations on them are. Personally, I conduct directions hearings remotely in almost every instance. I can't remember conducting a directions hearing in an arbitration on a face-to-face basis. As the arbitrator, you may well want to charge a separate fee because it involves a lot of work and a lot of preparation. The directions that you give are going to be need to be clear, and you are going to need to set aside at least an hour for the directions hearing. I will often hear them first thing in the morning or after the normal court hours, so that they don't invade the rest of the professional day. And there's no reason why, for instance, you shouldn't hear a remote directions hearing in an arbitration either at 8:30 one morning or at 6:30 in the evening, if that's what the parties want. Right at the start of the directions hearing, you're going to be asking, well, who's going to draft the order? At the end of the day, the order is that of the arbitrator. It's the arbitrator's order, and he or she must be satisfied with its content. So even if it is drafted by others, it's the responsibility of the arbitrator to ensure that the order is in the terms that the arbitrator thinks to be necessary. Again, right at the start of the directions hearing, is the recording system working? It is essential that it is. I deal with the issue of the seat of the arbitration for the purposes of Section 3 of the Act within the directions, so that it's out of the way, and you can then focus at the substantive hearing on the issues that need to be determined. You're going to state the seat of the arbitration is, for instance, London, Bristol, Birmingham, UK. The whole purpose of the directions hearing is to achieve an order. And as the arbitrator, you need to be thinking, what will I need at the final hearing? Be kind to yourself. Exercise foresight. Make sure that the directions hearing tees up the case for the substantive hearing in a way that will allow you to do the job that you then have to do. The directions hearing is not, of course, held on a without prejudice basis, and people need to understand that before they tell you things that they shouldn't, particularly litigants in person. Another issue, if you do have a litigant in person, is that you may have to address with that person whether he or she intends to seek legal representation, and you may have to deal with the issue of whether that person intends to seek a legal services payment order. That's a very sensitive issue to raise, and you have to raise it in a way that is not going to cause undue offence to a represented party, but does allow you to record that the issue has been considered with the litigant in person. Otherwise, after the substantive hearing, if the litigant in person is aggrieved, the litigant in person may use the absence of information on that issue as a basis for seeking to challenge the procedure. The directions need to record who attended. They need to deal with the filing of statements, from whom they must be filed. Always limit the length of the statements. Otherwise, you may get pages and pages of material. You may also need to record the format of statements as part of your directions and state what they must contain. You will deal with the question of whether experts should be involved. You will apply the same law as the court. I always require any expert to give an executive summary at the start of their report, and I limit the executive summary to either 2 or 3 pages. Think for a moment about how long it takes you to read 1 page of typed material. For instance, imagine it took an average of 4 minutes for each page. Now imagine in a children case, you get a psychological report that is of 100 pages in length. Well, that's 400 minutes of psychological report, and you could never read that in preparation for a directions hearing, so or for indeed a final hearing, if you're going to read the rest of the documents, unless it is essential. It is, of course, possible for an arbitrator to appoint the expert himself or herself under Section 37 of the 1996 Act. That has a lot of complications. With whom is the contract with the expert created? Who is going to pay the expert? And so I avoid that. I don't see why the arbitrator should appoint the expert rather than the parties. You are going to want to appoint a single joint expert in most cases, and the same Danielson Walker or GA and EL considerations will apply to any applications by one party to appoint a fresh expert. You'll want to give directions for questionnaires and responses to them in a financial case. You'll also want to record, and this is important, that no other documents may be filed without leave beyond those that are directed in your order. Bundles. Can I strongly recommend that there is a page limit that is set for bundles? I've recently done a court case where the bundle extended to over 10,000 pages. If you don't limit the size of the bundle, you will get far too many documents within it. The bundle needs to be prepared in PDF format and allow hyperlinking. And litigants in person these days are quite capable of producing bundles. I've just done an arbitration where there were litigants in person. They produced a very effective PDF bundle with hyperlinks. You'll want to set the date and the time of the arbitration hearing, but beyond that, you will also want to set a timetable. That timetable ought to feature in your directions, giving times for examination in chief, cross-examination, and re-examination. You'll want to record whether the final hearing is going to be remote or attended, and also how it will be recorded. An important part of the directions order will be whether the parties and witnesses are going to give oral evidence. As an arbitrator, you can, of course, take oral evidence. I can't remember doing an arbitration where I have not. And the arbitrator, you will conduct it just as you would a court hearing. It's important also in at least some cases to record that if a party fails to attend without sufficient cause after being given due notice of a hearing, the final hearing, that the arbitration may proceed in the absence of that party. That is in accordance with Section 41(4) of the 1996 Arbitration Act and Article 8.5 of either the financial scheme in a finance case or the children's scheme in a children case. If you think that a party may seek to, in effect, depth charge the arbitration process by simply not turning up, it is extremely valuable to find at the substantive hearing that you have remembered to include a direction to this effect. It then allows you to continue, because that's what the Act and the rules say. This also is a valuable direction for a directions hearing that you can see on the screen. It refers to Section 34(2)(f) of the Arbitration Act and records that the same rules of evidence, procedure, and substantive law will apply to the arbitration as would apply if the proceedings were being conducted before the family court. That is job done. It then allows you as the arbitrator, and indeed as the solicitors or barristers involved, to put the whole arbitration process into the context of rules, procedure, and substantive law with which you will be familiar. It is sometimes worth, at least, to refer to the fact that the arbitrator may order costs in arbitration. If you need to, you can look at Section 61 of the 1996 Act. Of course, in applying the same rules as would apply to a court, orders for costs may be rare, but in some cases it's important to record that there is that ability. You will also want to consider whether the parties are to give evidence on oath or affirmation. You have the power as the arbitrator to direct that they should under Section 38(5) of the 1996 Act. If you are going to have a party giving evidence on oath, you need to make sure that there is the relevant holy book available for the substantive hearing and who will provide it. You may want to say that the party who wishes to give evidence on oath must ensure that a suitable holy book is brought with them. If they're going to give evidence on affirmation, then that needs to be recorded. You, as the arbitrator, need to know the words of the oath or affirmation so that you can ensure that they give the oath or affirmation in the correct way. I've learnt those by heart. They're not difficult. And I think it adds a degree of formality to the process. If at the outset of evidence you can look a party in the eye and say, please repeat these words after me. I do solemnly, sincerely, and truly declare and affirm that the evidence I will give will be the truth, the whole truth, and nothing but the truth. The directions need to record that there may be no further documents without the arbitrator's leave. And in some cases, you may want to discuss the arbitration directions hearing, whether there's going to be a private FDR before a financial arbitration, or whether the parties want to engage in mediation before it. If they are, the timetable will need to record that. So what are you wanting to achieve from directions? An order that is very similar to the order that you would create in court. You will have headings, but not, as I saw recently, a heading that included in the family court sitting at, or in the central family court. You're not sitting in court. The order will include recitals. For myself, I studiously avoid the repetition of upon and upon. I don't see why we do that. I simply list the recitals 1, 2, 3, 4, 5, and make them as clear as I can. The recitals may want to record what the issues are, what the state of any parallel court proceedings are. They may you may want to remind the parties of the duty under Section 40 of the 1996 Act that they have to support the proper and expeditious conduct of the arbitration. And then you will put, it is ordered that, and list the orders that are being made. It is an order. Please use plain English. Do you really want to say file? Where are they going to file documents? In fact, what you'll be saying is, please, you'll be directing them to send the documents, to you as the arbitrator and to the other parties. I tend to avoid referring to people as applicant and respondent and refer to them by name. Avoid using, giving a direction that things are to be done within a number of days. Give times and dates. Make sure the directions are realistic. Allow yourself plenty of preparation time following the receipt of the bundle. So allow a gap between the filing of the bundle and skeleton arguments and the hearing. And in your direction for skeleton arguments, set a page limit. Otherwise, you will get very lengthy documents. After the directions hearing, the arbitrator needs to make sure that there is a completed order. The order is not sealed. It doesn't bear the royal crest. It is not in the family court. If there are, after the directions hearing, applications to vary the timetable or other directions, I would strongly recommend that you deal with that by issuing an order. Don't deal with it by email alone. If a further directions order is genuinely necessary, are you going to charge a separate fee? As an arbitrator, you will need to make sure that you put realistic preparation time into your diary. You will also need to put in a realistic amount of time that you will need to write the determination or judgment. Sometimes it will take days to write the judgment. I have one coming up where I've set aside uh, at least 3 days to write the determination. Don't cut corners. Don't be unkind to yourself. Another point is you must be careful about discussing the case with others, however much you might want to do so. At the hearing, I would recommend that you, as the arbitrator, are present before the parties arrive so that you can greet them. It adds an air of professionalism to do so. You will again check that the recording is right. You'll want to check the room layout so that the parties are not eyeballing each other. If you, as the arbitrator, sit at the head of the table with the parties on either side, you may find that the husband and wife or mother and father are left only a few feet apart across the table, and that can be extremely difficult for them. You need to make sure that there are appropriate conference facilities for them all, and that the conference facilities are of an equal standard for both parties. You will want to start on time. If people want more time, they should request it formally in a way that is recorded so that there is no doubt about what has occurred. As the arbitrator, you also need to stick to the timetable. It's difficult. If you have a legal representative exceeding their timetable, you will want to remind them politely but firmly that they are doing so. If you don't, then you will pay for it later on in the day, and it may mean that the arbitration cannot be completed. One way of speeding things up is to ask whether an opening is genuinely necessary, bearing in mind that you've read the papers. At the start, you will, of course, want to deal with any housekeeping issues that arise. But do you really need an opening? Very rarely do I allow one. If you're going to ask questions yourself as an arbitrator, it is very wise to formulate the question first. There's nothing worse than thinking that there's a question that you want to ask, interrupting an advocate, and then coming out with a question that is garbled. It means that the legal representatives before you will think that you are not up to the same standard as they are. So I write the question down before I ask it. Be polite, but be firm. I think as an arbitrator, you need to avoid humour, save in circumstances where you are very sure that you're on safe ground. Don't be autobiographical. People don't want to know about your children, your views about life in general. They don't want to hear your anecdotes. They are there to deal with the issues that they have brought before you and asked to be determined. As the arbitrator involved the parties, it is their hearing. They respond well, in my experience, to you taking an appropriate opportunity to talk to them directly as fellow human beings. Do remember that for the parties, the arbitration hearing will be extremely tough. They will need breaks, and a few 10-minute breaks during the day will allow everyone to focus on the job in hand. Do take lunch, and do, as the arbitrator, give yourself space within the day. I think it's really dangerous to speak to one side of the arbitration in the absence of the other. It may be difficult in a solicitor's office or in a set of chambers. You may bump into one of the other advocates or one of the other parties. Be extremely careful about talking to only one side. And if you're going to speak to lawyers in the absence of the parties, you have to make sure that the recording is running while you do, and that both parties have given consent for that to occur. Otherwise, you will be accused of unfairness. When you have as you will have occasionally, the stroppy or frustrated party or lawyer, or the prolix lawyer, or you have issues of distress or evasiveness. That is when your training in transactional analysis and your recollection of the drama triangle that I discussed earlier will need to kick in. Don't respond to stroppiness with your own stroppiness. Taking a note is essential. You need to take that note in a way that will allow you to remember what has been said when you come to write your determination. And if people are going too fast, you need to slow them down politely. If in doubt about your note and about what someone said, check it then. Do it straight away. Don't leave it till later. Don't be afraid to say, I'm sorry, I'm not sure if I've got a proper note of this. My note says this. What do you say? And you will sometimes find that the note that you've taken is not right. And if you relied on that note in your determination, then it would be challenged. There is a thing called active listening. You're not engaging in casual listening, the sort of thing that you have in an everyday conversation, nor are you engaging in complete listening where you are only focused on the precise words that are being used. You are not there just to take a transcript. You are actively listening to what is being said. That active listening has been said to require something like 70 or 80% of attention. And at times will involve you engaging in a dialogue. Engaging in a dialogue is one thing. Constantly interrupting is something else. And please, as the arbitrator, don't do that. You will know what it's like when a judge does it. Don't be that judge. And also, there will be times, I'm sure, when as the arbitrator, you'll think, well, why doesn't he ask that question? It's the obvious point. It's what he's trying to get at. Why didn't he just get on and ask it? Be careful. Make sure the question is asked, but don't do it in a way that's critical. Think about the training also that you have about telling how you know what the truth is. Are you in fact there to establish the truth? You're not playing God. What you are there is to make a decision based on law and procedure as to what is reliable, what is credible, and what conclusions you should reach on the evidence. Be careful about reaching decisions based only on demeanor. There's a lot of case law on that. People will know, and remember it. A lot of communication is not just through precise words. It is about body language, manner, and tone. You'll take that into account when deciding on whether a witness is credible or reliable. But don't just do it on the basis of how a person appears. You'll want to cross-check your conclusions with contemporaneous documents, and that is one of the most reliable ways of reaching a correct decision. In closing speeches, do you just sit and listen? Well, I allow advocates, I hope, to develop, or litigants to develop their arguments, but I want to engage in the process. It should be there to help you as the arbitrator to clear your thoughts. I'm very cautious about saying that parties can engage in written closing submissions, particularly if that is a request that arises because people have overrun the timetable. I keep to the timetable, and I much prefer to deal with submissions orally. Otherwise, you may get pages and pages of material that you would simply cut through in oral submissions. You may, if you are going to have written closing submissions, want to raise the question of whether that requires a separate fee. But why are written closing submissions necessary? And please don't sit late. It's tempting, but if you sit beyond normal, way beyond normal hours, people will be too tired to conduct the case properly. So as to the determination, and this is the last stage, what do you look for in a good judgment from a court? Think of that, and as an arbitrator, use that as an example of what you should include in your determination. You can, of course, begin writing some aspects before the arbitration. You can create an initial account of the history from the papers. You may want to think about an outline of the law. I don't think it's wrong to do that, but you can never start drawing conclusions, either in relation to facts or law, before you've heard the case, and avoid doing that. It happens. Who is the determination for? It's for the parties. It's for the lawyers. It's for the court or any appeal judge. But it's also for you. It's your work, and you need to take pride in it. So do take care about the determination. Plan it. Don't rush it. Tell the parties when to expect it, and keep to the timetable that you set for yourself. I would never dream of sending out a determination in note form. It should be capable of being read as a standalone document. As to format, I would recommend using headings, such as giving an introduction, then setting out the law, then giving the details of the parties, for instance, the children, the assets may be set out in an appendix, give a chronology of the facts, record key findings, then have a section that is headed analysis, in which you must apply the law that you have stated to the facts that you have found, then a conclusion, then set out what the award is. Can I emphasize the importance of the analysis part of the judgment? On occasions, as a judge, when I was hearing appeals, I would get a transcript where I would hear chat, discussion, and then the judge would say, this is what I'm going to do. That's not good enough. The analysis is where you draw everything together and say what you think and why. And you need to do that clearly. And I would recommend that where you do reach conclusions on issues, you enumerate your reasoning. I have reached this conclusion on this issue, and I have done so for these reasons, 1, 2, 3, 4, 5. Be brief, avoid repetition, avoid cutting and pasting huge chunks of law. This isn't an opportunity for a display of academic brilliance. You only need to recite the law that has to be applied for the proper determination of the case. Of course, you may cite necessary statutes. The more important thing is not just to cite the law, however, it is to apply the law and demonstrate that you've applied it within the analysis section of your determination. Ask yourself, do I really need authority for this proposition? You also will want to demonstrate that you have considered the submissions that have been made by the parties and their representatives, and give a summary of it, not just cutting and pasting skeleton arguments en masse. A determination should be in formal language. If in doubt about the meaning of a word, look it up. I do that frequently, and I'm surprised by my own lack of sufficient understanding about the meaning of some words. You can do that nowadays very easily on AI. The determination must stand as a standalone document. It's there not just for the present, but also for the future. Don't be arrogant within the determination. You'll remember how in Roman times the emperor would have a slave whispering in his ear, remember the gods. Don't get judgitis. One thing that you may find helpful is to mentalize. How would you want a member of your family to be treated by an arbitrator? Use that as a standard for your own conduct. As to the order or award, is there any reason why it should not be in the form that a court would issue, albeit with different headings? It is worth mentioning the right to apply to court in accordance with Haley and Haley and A&A, just as it is wise in a court case to raise openly and without embarrassment the possibility that a party may wish to seek permission to appeal. Don't shy away from it. The order must be clear. If anything is challenged by an application to the court, it will be the order that you make. Be careful about requests for clarifications. It is not for the parties to cross-examine you as the arbitrator after you've reached a decision. Sometimes it happens. I had that in an arbitration last year, where after a very full financial determination, I had a list of things that were said to be clarifications and were not. And I declined to deal with any of them. Be prepared to do that. If someone is trying to cross-examine you as an arbitrator, just say no. And that's it. That's the end of this talk. Thank you. It's taken some time to get through all that material. I hope you found it helpful. It's a really interesting area of work, this. And the more I do, the more I realize that it has a requirement for very specific skills. So I wish you well within it. Thank you.